good morning to everyone. I'd like to really welcome you here at another event happening with OSBA Meets. And I would like to really warmly welcome Lucas here in that round for OSBA Meets. Let me briefly introduce you, of course, and to the participants here. And we have already been saying at the very beginning of that call that it couldn't be more actual than now since yesterday, but I will keep that point later to you. And just as a short introduction, and of course, we are going to have a Q&A, and please, with that Q&A, raise your first name and activate your camera. And as said, this will not be recorded. Lucas has a background in contract, technology and telecommunication law. Prior to Free Software Foundation, Lucas had experience in Brazil and Russia with e-commerce, transfer and technology, telecommunication, and arbitration. Over the years, he got experience in the academic sector as well, achieving a master and PhD in law. For him, free software is a precondition for a safe, neutral, and healthy digital environment. At FSFE, he is working as a senior project manager. And just to, on a very, very high level, give you an overview about the Digital Market Act. And as said, we have had some news about that since yesterday. So very, very good timing to have you here. But on a high level, the European Union Digital Markets Act regulates large digital platforms, gatekeepers, and is intended to promote fair competition and innovation in the digital single market. New obligations such as interoperability, ban of self-preferencing, and the opening of app stores will create improved access options and new opportunities for innovation for open source software. Indirectly, the Digital Market Act favors open source projects as market entries. Barriers are lowered, and alternative software solutions can reach users more easily. And saying that, there has just been published news yesterday. The European Commission has fined Apple and Meta millions for violating the Digital Markets Act. The accusation is that they have exploited their market power in a prohibited manner. Apple is accused of restriction in the App Store that make it more difficult for other companies to access the market, while Meta is accused of offering fewer AdWords. And if you look at the current use of language, the lawyer's assessment is, of course, judgment is unfair. This is what we really, really often hear, actually. So, as a very, very short introduction of you, Lucas, and the DMA, the stage is now yours.
Thank you, Uwe. It's a great pleasure to be here with you today. I'm happy to establish this collaboration with OSBA. I think it's my first time with you, and this is awesome. I'm very happy, and thank you for having us here, having me, myself, my colleague Dario as well. I thank you, Uwe. I thank you, Miriam. I'm very excited to talk with this audience about the Digital Markets Act. The free software community is pretty much into the CRA, the Cyber Resilience Act, and no love is given to the DMA. But I would like to change our perspective to invite you to reflection today and to see the DMA as something very close to free software and differently from the CRA that impose things on free software. The DMA is the one that we can use in our favor in order to impose obligations on proprietary companies, the largest one, in order to have better position for free software. For those who wonder who the FSFE is, I think you know us, but very quickly, we are a charity that empowers users to control technology. We represent the interests of free software in Europe. Although we are small, relatively small, we have a huge amount of volunteers that work with us, and our activities is more public awareness, regulatory changes, advocating for policy changes, and legal interventions. We will speak about this in a minute. As an independent non-profit organization, we received donations from individuals and also corporate, and some of the gatekeepers donate is among our donors. However, the FSFE receives no donation higher than 20% of its yearly budget. I think it is important to mention in the context of the DMA. Well, as I said, I would like to introduce to this audience the DMA as an enabler for a small business, especially for the free software ones, and to run over its opportunity. And I would like to show to you that we have been involved in the DMA since the legislative process, and there's a lot of to talk about, and recent victories as well, not only the fines of yesterday, but also more structural changes in relation to interoperability that for sure will increase the opportunities for free software. Last but not least, how you can help us in this task, in this quest in making the DMA free software friendly. So I would like to start with a question for the audience. Do you think that we have control over our devices? I think I can start a poll here. It's just true and false. What do you think? It's completely just for fun. Do we have control of our device? Okay, so I see there is a lot of people commenting here, and I will publish the poll right now, just for us to have a look. All right, so yes, I think the majority thinks that we don't have control of our devices. Miriam said Lineal Age and F-Droid feeling good. I agree with you, Miriam. I also use Calyx X and F-Droid myself. But I think the audience is right. The sad reality in digital markets is that we run out of control. Devices are not neutral, and the very basic fact when we buy an Android or an Apple device, the first thing that we have to tackle is that they prompt us with online account that we need to sign in order to start using the device, and then we enter in the logins. Then we see that we have no access to third-party app stores, for an example, before the DMA in Apple devices. The interoperability policies are very low. In the end, even side loading is blocked, and therefore we are not able to run different operating systems easily in our smartphones. So software freedom is also deeply impacted on this. And why is this? Basically because the digital market for the operating systems in mobile devices are extremely concentrated. Apple and Google had 99% of the world market of operating systems. Of course, Google is way ahead of Apple, but Apple also dominates in several markets. Recently, I was in Japan. I talked to the telecom regulator in Japan, and they informed me that Apple has 50% of the sales of smartphones in Japan, for an example. However, there are free software operating systems alternatives in mobile devices, right? However, in this graph, we see that the number of people using it is extremely low, right? And therefore, the power that these companies, both company Android and Apple, exercises of end users is extremely high, and therefore they can, basically exercise this type of gatekeeper control over our devices. However, then it's not only the perception of our community of this lack of empowerment of users, but in 2021. The European Commission already, based on several studies and from telecom regulators all over Europe, for an example, in 2018, there was a very good study from the French telecom regulator on smartphones, that they realized that something had to be done, right, on the legislative level. Right, and the reaction to this situation in digital markets was the Digital Markets Act. As Uwe already introduced, the Digital Markets Act regulates the economic behavior of the largest tech companies in the world. So the DMA, it's not for all companies, right? Differently from the CRA. The CRA applies to everyone that's producing digital devices. The DMA is only for a handful of companies, right? I think it's 6 companies right now. It's the GAFAM, right? But TikTok is also included, and Booking as well is also included. And But I think that although the law doesn't explicitly mention free software, also differently from the CRA, the DMA is neutral in this regard. There is no mention of free software. I do believe that free software is extremely important for the implementation of the DMA, but also DMA is very important for broader adoption of free software. So it's a symbiosis in two hands. First, we needed to consider that free software is contained in basically every software that is produced nowadays. There is a research in 2023 concluding that 96% of all code bases being scanned contain free software. In 2022, the European Commission performed a survey in the software industry in Europe, and they concluded that 94% of the software development in the EU are done by SMEs with less than 9 employees. So differently from the Silicon Valley, the software industry in the EU is done by SMEs. Therefore, our position is that DMA is not only about competition among gatekeepers. It's not about Google versus Apple, Apple versus Amazon, but DMA is also protecting the interests of small tech as access seekers, as Uwe also mentioned in the introduction. So we want to make sure to change the landscape of digital markets, the digital markets in Europe, not only regulating the competition among these companies, but also introduce new competition in the market. And therefore, this is very important for free software companies. We think that the DMA is important for leveling the playing field and to enable innovation by introducing new alternatives in the Digital Markets Act. And as we know, the free and open source is all about innovation. Well, very shortly now, bear with me, it's a little bit of legalese, but I promise you that it won't be that boring. The DMA, as I said, it applies only to a handful of companies. And this, in order to apply to a company, the Commission should designate this company. So there is a process conducted by the European Commission in order to designate. Moreover, the Commission should also designate to which specific service the DMA will apply, right? So there are two processes that the Commission should perform. One of the company, and second to we call the core platform services. And we highlight here what are the services that are interesting for free software. The DMA applies to online search engines, to operating systems, to online intermediation service. For this is the name for app stores, for an example, under the DMA. And also to cloud services. The DMA is not explicitly applied to AI. However, our position as the FSFE is that once AI is incorporated as a feature in one of these services, the DMA can also be applied to it. This is our position. And of course, as I said, there are several provisions that are relevant for free software, different from the CRA, where the provisions apply to free software companies. These provisions apply to big tech. And under the provisions, the access seekers, the free software access seekers could benefit from it. For an example, Article 6.3, obligation to allow app software uninstalling and changes to default settings. 6.4, obligation to allow third-party app stores and side loading. For an example, until just recently, until the DMA, it was not possible to install different app stores in iOS devices. Now it is possible. Obligation to allow interoperability with hardware and software features. This is key, and we'll talk a little bit more about this in a minute, because we are involved in litigation against Apple on this. And also interoperability in messaging apps. So as we see, there's a lot of common ground with DMA and free software. So I would like you, the Belgian Competition Authority prepared a brochure for SMEs. They are calling tech challengers. I like the term. And Dario, would you be so kind to send the link in the public chat? Also, if people would like to check. It's basically a short guide how SMEs can profit from the SMEs from the DMA. I'm sorry, right? And so this is all about enabling and lowering the threshold for companies to access the infrastructure in digital from the gatekeepers in digital markets, so more competition in this area of the services can be implemented. This is more or less what the European Commission has been doing since the 90s in the telecom sector. Remember, in Germany, we had the almighty Deutsche Telekom that was the incumbent responsible for the telecom system, and other countries. There were other ones, TIN in Italy, and you name it. But then competition was significantly increased during the 90s and the 2000s, when the new generations of mobile internet, and today's we have different operators in your countries, and the reason behind the DMA is more a little bit more like that. However, telecom markets are simpler, if you will, are not that complex as the digital markets, right? And therefore, the rules containing the DMA is much broader than the rules containing usually on the reform of the telecom law. So I can already name some of the changes in digital markets that the DMA brought with it, right? So, for an example, on the choice of browsers, now users are prompted with a screen, a choice screen for choosing their own the default browser, right? On app stores, as I already mentioned, Apple did not allow any app store to run on iOS. Now, alternative app stores are being allowed. Look, the war here is not won yet. There is still a lot to be achieved. For an example, Apple still imposes several hurdles against alternative app stores. They require a letter of credit of 1 million euros. There is several taxes that they impose on alternative app stores. However, even before that, they blocked completely alternative app stores, right? And we are working very closely with AppFair. We have just released an interview with AppFair. Dario, perhaps that would be also good for the audience to hear this podcast. We record a podcast with AppFair. It's one of the few free software app stores that are available for iOS, and they are doing an amazing job. And I think it would be super cool to check. Last but not least, the Trump administration has been very sad and very angry with the DMA. Every day there are comments from the Trump administration, even the U.S. Congress, is saying that DMA is derogatory, DMA is discriminatory against the U.S. companies, and they trying to push DMA into this trade wars. However, I would like to point out to this audience that the rules containing the DMA, it's not a specification or a specific context of only from the European Union. It's a global demand. We are seeing these rules being published and being enforced all over the place. So in Australia, they are preparing a new digital competition regime. In Brazil, Apple also was fined by sideloaders obligations from the competition authority. We took part, for an example, in Japan, where they passed already a law for mobile ecosystems, very similar to the DMA. We contributed to this law. South Korea and even UK, there is a new law that is very similar to the DMA. So we are seeing that world has understood that big tech is bad, literally, and we need the smaller tech in order to have a fair competition. Therefore, in the FSFE, when we took part in the debates with the decision makers, we are not framing DMA as US versus EU, but we are framing DMA as big tech versus small tech. So, as we said, and just to keep it short, we have been working very closely with the European Commission. We submitted 3 deep studies, how DMA is important for free software. And we have been working with more than 10 free software projects, alternative app stores, alternative payment system, GNU Taler, Tor as alternative browser, AppFair, F-Droid, emulators, and an array of projects, and we are collecting their demands. And for example, when they interact with Apple, when they interact with Google, and we have published several studies. And one of the studies was even accepted by the very renowned Yale University in the Knight Georgetown Institute in Washington, D.C., where we also discussed this with members of the enforcement team of the DMA. We also work with civil society, Article 19, EDRI, and other organizations in order to defend the interest of free software. For example, in last year, the whole year, we were in bilateral debates with the European Commission regarding Apple's policy towards interoperability, right? And this is critical because several already free software projects, GNU Thaler, for example, I think you know GNU Thaler, it's an alternative payment system. They required from Apple access to NFC chips, and Apple denied it to them, right? And without access to NFC chips, GNU Thaler cannot properly work in iOS devices. So we have been, this is just an example, we have been working with several free software projects, and we prepare, and we are very happy that the Commission heard our demands. And for an example, before we go, yes, here's the first, thank you. Yes, so we, together with members of the civil society, we submitted several studies to the European Commission starting February last year, and then we had several calls with them, and we participated in conference with them, highlighting how interoperability was blocked by Apple to free software projects, right? In December last year, they published, the European Commission published a new specification under the DMA, improving a lot the interoperability policy for Apple, right? So it was amazing. Apple had a very, very simple, and yeah, it was cringe, the process that they had for granting interoperability for free software projects. So no transparency, no appealing process. It was not possible to even check the status of the ticket. And then we highlighted this to the Commission, and the Commission prepared a huge document imposing on Apple transparency obligations, arbitration obligations. So now, for an example, when they deny interoperability access to free software, there is an appealing process. And then if the free software process also, for projects also loses in the appealing process, they can go into the third instance with a third-party conciliator. So literally, we really pushed forward the interoperability policies against Apple. And in March, the final decision of this procedures were published, and they will soon be enforced against Apple. So it was a victory that we achieved against Apple. And also, as you've mentioned yesterday, we finally saw that the DMA has big teeth. For the first time, the European Commission imposed, as a conclusion in investigations under the DMA, a 500 million euro fine on Apple for non-compliance with the DMA regarding anti-steering practices. Meta was also fining 2 million euros for their pay and consent model. But here we can see that we see fines being imposed, but also structural changes, for an example, like this interoperability obligations. Apple, unfortunately, will not become Google in the sense like where we have F-Droid that is much easier for free software, but we are working hard to make it easier for free software to be present and to be distributed in iOS devices. And we are even going to court and to make that happen. We didn't start this litigation against Apple, but Apple started this litigation against the European Commission. Remember when I told you that in order to DMA to apply to companies, the European Commission should designate the company and should designate also the service, the specific service of the company. And the first thing that Apple did, the first thing, the commission designated Apple in September of 2023. In November of 2023, Apple appealed the designation decision to the Court of Justice of European Union. And the arguments that Apple is putting forward, it's amazing. They are claiming that the entire DMA is illegal against the European framework of human rights. This is absurd. They are saying that the DMA is not compatible with human rights. And I will talk with you about this in a minute. So what we did, when we saw that, we said we need to intervene somehow. And we were very happy that a former intern of the FSFE, a brilliant person, today he is professor in London, professor of law in the London School of Economics, Professor Dr. Martin Husovic. And he's a lawyer. He has tons of experience also representing civil society. And we reached out and said, what about this? And he was happy. And we decided to intervene. And he's representing the FSFE there. And in August 2024, we were accepted to the court. And look, this was already a victory because this was big dog litigation. It was Apple against the European Commission. And the European Parliament is intervening. The Republic of France is intervening. And then there is the FSFE with 20 employees also intervening there. So it is super cool. But our arguments are very strong, and Apple was trying to block our participation in this court case by all means. They requested the court to make the documents confidential. But in February this year, very recently, the court denied this request to keep the documentation confidential. So we are progressively going forward in this court case. And what is about this court case? So basically, as I said, Apple considers that the interoperability obligations in the DMA is against human rights. They are saying that the interoperability is against their right to property, intellectual property. It's against their right to conduct business, right? And therefore, they say that Apple should not be designated under the DMA, and the DMA should not apply to iOS, Apple Store, and iMessage. However, our position, this is all public information. It's all being published in the site, in the website of the court. We are claiming that the interoperability does not necessarily involve intellectual property rights, and Apple is being regulated because as soon as society grows in complexity and we start to depend on fundamental and very important infrastructures, this company should be regulated from the perspective of public interest. We use our devices on an everyday basis, and we are completely blocked in our freedoms, especially in our software freedoms in our devices, right? So as soon as these companies become so big that they dominate in digital markets, they should be regulated. And the DMA was approved under a democratic process in the European Union, right, in the European Parliament. So these rules are completely compatible with human rights in Europe. The article in question that they are very much against it is Article 6.7. I would like to very quickly read to you, because this is awesome for free software. The gatekeeper is Apple. The gatekeeper shall allow providers of services and providers of hardware free of charge effective interoperability with and access for the same purposes of interoperability to the same hardware and software features accessed or controlled via the operating system. It means like if Apple controls hardware or software feature that is accessed under the operating system, they should make this system available for third parties. This was the case, for an example, with GNU Taller. GNU Taller access to a hardware feature. For an example, we have free software projects that are accessing that are requesting to have access to software features, and Apple has been blocking that as well. So this article is very powerful. This article is one of the key aspects of the DMA because it really lowers down the threshold for accessing such infrastructure. I reached the end of my presentation, but I have some homework for us. I really would like to foster this qualified audience to help us in this process. For an example, with networking recommendation, we appreciate suggestion, connections, contacts, and people interested in the DMA. If you yourselves or you know people that are interested in the DMA, or for an example, you requested interoperability with Apple, with Google, with Microsoft, with Amazon, and you had your request denied, please reach out. We are studying on this. We are working with the Commission on this. Raise awareness, help us spreading the word about DMA. Yesterday, we had these fines, and it reached the headlines in every newspaper in Europe. So we are seeing that there is a lot of interest, but at the same time, there is a backslash, especially from the US. People in the US are being bombarded by the media and by Trump administration against the DMA. And we want to put forward the idea that the DMA is not against the US. We have nothing against the US. The DMA is against big tech, whatever the big tech is, because big tech is bad for digital markets. And finally, but not least, we are not for profit and we rely on donations. So if you want to contribute with our work, this is super appreciated. And I thank you very much for your attention, and I look very much forward for your.
So thank you very much, Lucas, for having you here, and of course for the categorization. It really, really helps us to better understand, of course, the importance of DMA. And I have to be really frank here, and I totally agree with your assessment. The importance of the DMA is indeed completely underestimated. So yeah, we will see and how we can contribute here, rising, and I really like that point, raising the awareness, because I completely think that regarding our political representatives in Parliament, additionally, are not completely aware here of the Digital Markets Act. One point I'm interested in is in your view about how is the Digital Market Act contributing to sovereignty and resilience?
Yes, this has been a very, very good point. And let me just very quickly here share with you. Yes, here. So, during the discussions with the Commission, I took part on a huge conference last year in June, organized by the Commission with the Association of all telecom and competition regulators in Amsterdam. I think there was 400 people there from companies all over the place, and I raised this question. I said, look. What is the strategic goal for the DMA? We want only to regulate big tech, but then we want to create our own European big tech. So we want, so we are envy of Silicon Valley, and we want to have the European Silicon Valley, and therefore, having European proprietary companies. Or we really want to change the structure of digital markets, make it more competitive, make it more fair, and therefore, if we want to do this, it's very, very important that we think about an idea of sovereignty and resilience that is based on free and open source, right? So. If we really wanted to change the landscape of digital markets, we need to think about not only making whole in the infrastructures of this big tech, but we needed to foster newer European alternatives. And here, Uwe, for example, recently, I don't know if people in this audience followed, there is a huge project funded by the European Union called Next Generation Internet. It's more than 20 million euros invested in free software, right? However, they decided to cut this. And at that time, I said to the commission, to the representatives of the DC Connect, that is the directorate that is responsible for NGI, and we said, look, guys, we have the DMA. If we wanted to foster a European solution, we need public money in order to foster European companies working with free software, right? So here, I think that the DMA is not only, as I said, about competition among these companies, but also protecting the interest of small tech, and in particular free software. And therefore, the idea of sovereignty based on free and open source is very important.